which can help us landing job as an in-house legal counsel. So we wanted to break that barrier. So that was the reason why me and Achal we launched this course. Rest, I believe Achal has already told you about, which Achal will tell you about uh, later on in the session as well. So Achal, we can start with the demo session and then we can brief them about the course later on.
Sure. So we'll just start. I'll just share up my screen. We'll start with the demo session. Okay. So let me know once the screen is visible.
Yeah, screen is visible now.
Okay. Perfect.
Wait, Achal, it's not visible to me. Okay, now it is. Alka, is it visible to you? I hope it's visible to you as well. Hello, Alka, are we audible?
I think.
Yeah, I'm not sure if. So you had a word with Alka, Achal. You got her introduction because I'm not sure if she is able to hear us or not.
No. I think there is some issue. So let her join it again.
Sure, sure.
Okay.
Okay,
You.
so we'll just wait for a minute and let's Alka join again and then we'll begin.
Yeah, sure. Yeah, Pragya. So, Pragya, I am having just one doubt. As you said in your bio as well, that when you were appointed as a legal counsel in any of the companies, so yeah, there was no guidance and nothing is there
Right,
to support to the similar thing I am also facing in this startup company. There is no such senior. I am just having the knowledge of the secretary and the labor compliances. Okay, and I am very
right,
little information about the contract, so I'm not getting from where to start because there is no such literature like in GST. There is an act, there are the rules, and there are the forms. There is a calculation mechanism. In Companies Act,
right.
there is an act, rules, and all the. But in contract, I am not getting, and I'm completely perplexed from where to start and how to get into the negotiation, how to get from the scratch or the contract. That's why I have joined your session to give me the insights on the same.
Yeah, exactly, Harsh. That was the issue that we face, and a lot of students, lot of youngsters and freshers like yourself, they still face the same issue because if actually there is nothing or
Hmm.
sort in the market which can provide you practical training. And the
Yes.
previous batches that we have received tremendous feedback from them because this is the first kind of a course that you will find in the
Hmm.
market. There is no other like any other company or organization or tech platform actually providing practical training because they are in initially from the beginning they are an tech platform, so their motive is to make money. They didn't have that practical training. They were not in-house legal
Okay.
counsel themselves. So me and
Hmm.
Achal,
Hmm.
since we were legal counsel, in-house legal counsel, we have worked
Hmm.
for over 5 years, so we know what exactly what do you need to keep in mind while drafting, negotiating, reviewing, that sort of thing.
Yeah, that's why only I was interested in your course and I gone through your post on the LinkedIn. That's why I contacted you and Achal for the same so that I can also register for this course and it can be when I can join from the next month onward. And Achal said it will be coming from the first week of the Feb. Yeah.
Yes, right. I think Pragya,
Yes, right.
let's just start with the session. I
Yeah, sure.
have
Sure.
started the recording also. We can share the recording with
Okay.
all the participants. Let's not just waste time. We have other batches also for the demo session. So let's
Perfect.
just start with
Perfect.
it.
Perfect.
Yeah.
Okay. So, Harsh, as you can see, we have this is one of the specimen of an actual agreement which in-house legal counsel get, and out of that, and in an agreement, one of the most important clauses is payment term because every company is working for money, for
Yes,
revenue, for
when we are
profit.
entering into the customer or the suppliers agreement. Yeah, obviously.
Right. Right. So payment term is one of the most important clauses. So we have handpicked two of the sub clauses under the payment term, sub clause 3.1 and sub clause 3.2. So I'll read it out loud for you. So sub clause 3.1 says that subject to satisfactory performance of the services by service provider, ABC. ABC here is client. Okay. Now ABC shall pay service provider fees as consideration in accordance with terms and conditions of this agreement for rendering the services. Service fee is inclusive of taxes if any levied under the applicable laws except GST. GST shall be payable by ABC at such rate as prescribed under the applicable law in addition to service fee and in subject to fulfillment of the conditions prescribed under clause 3.4 of the agreement and annexure 2. Payment of the service fee will be subject to withholding of tax at applicable rates. Now, Harsh, a quick question, like considering clause 3.4 and annexure 2, they are good to go. They can be agreed upon. According to you, what do you feel? Clause 3.1, would you suggest any change? Or according to you, this is good to go. We can agree from service provider's side.
Wait, but the verification should pay the further GST. GST according to me, Pragi, I am not getting anything in this that it is contradictory to my company being the customer.
Okay. So, any change that you would suggest that you feel this is not okay? I want to change this language. I want to add it or delete it or modify it.
No, Pragi, for me, if I look at it from a very layman point of view, so I am looking that it is good to go with this. But you can tell me more on the practical inside of this particular clause. Yeah.
Sure, sure. I'll come to that later. So 3.1, according to you, it's good to go from service provider's point
Yes,
of
yes,
view,
because
right?
because of the logic that it is only speaking that the service provider will pay a particular fee which is mentioned in the agreement and the applicable taxes will be paid and GST जो होगा that will be paid by the ABC as per the respective law
Right,
जितना भी उसका rate है and the fulfillment and there are certain
right.
conditions which need to be put in 3.4. So I guess this clause is good to go. There is nothing which is critical to any of the parties in my opinion.
Okay, all right. Okay, so now we'll move to clause
Hmm.
Achal, yeah. Okay. Now we'll move to clause 3.2. I'll read it out loud. Okay. Clause 3.2 states that ABC shall be entitled to retain or withhold any part or whole of the service fee, including GST, if any, payable thereon, in the event the service provider breaches any of the material terms of this agreement or is not in compliance with the conditions stipulated above until the same has been complied with or the requirements under the applicable law in relation to this agreement has been adhered to. Such retention or withholding by ABC, that is client, such retention shall not be deemed to constitute a breach of ABC obligations under this agreement, and service provider agree that it shall not seek any remedy, relief, or claim from ABC in relation thereto. Now, again, Harsh, considering you are from service provider's point of view, and ABC has sent you this draft. So,
Hmm.
under clause 3.2, do you feel any change, or it's good to accept from service provider's point of view?
Wait a minute.
So,
In my opinion, in this case, the ABC cannot retain the GST because if I am being a service provider, if I am paying the GST to the government,
mhm.
then it should be cleared on a first instance basis regarding my consideration of it. He can withhold if there is any material breach of any of the terms of this agreement, which I can get from this 3.2 clause. Such a retention withholding liability shall not be
Okay, so according to you, they can retain or withhold your service fee, but they cannot withhold GST, right?
GST.
So I
Yeah.
believe so. You would remove the word in second line, including GST. You would remove these words, right?
Yes, not including GST. Or except the GST, we can do them. Yeah.
Right. Okay. Apart from that, any other change you feel you might want to add in this agreement?
Or is not in compliance with the conditions until the same has been complied with or the required applicable relation with the to such a retention withholding by ABC shall not be deemed to constitute a breach of any such a retention or withholding by ABC shall not be deemed to constitute breach of ABC and the also agree that shall not seek any remedy. I guess this is the second last line is on that the service provider agree that it shall not seek any remedy or relief or claim from the ABC. I guess it is completely against the service provider's obligation because there should be some resort to seek a remedy or relief or get into the discussion with the ABC, who is the client. That I guess it shall not seek any. This is something which is not good to go in this particular point.
So I believe you would tend to delete this language or you want to modify it.
I would be agreeing to modify it that a service provider can seek the adequate remedy or relief for claims from ABC in relation thereto, subject to the fulfillment of certain conditions or the rectification or the modification, whatever the glitches have taken place. On that basis, there should be some. Service provider should be given certain time that within this period of 14 days, if the
Mm-hmm.
if the deficiency in services is rectified or modified, then the ABC shall be making the payment to the service provider, and through this, and if he's
Right,
thereafter not making my payment, then I can seek any of the remedy relief or claim whichever is given to me by law.
right. Okay, perfect. Perfect, Harsh. So now we'll move to the changes that we have made in 3.1 and 3.2. Ajal, we
Okay.
can scroll down.
Okay, so like just a minute before scrolling it down. So Harsh, see, basically now there is in this session or in the course there is nothing like as we gonna judge you or any of the participants of what all
Sorry, Achal,
you.
your voice. Sorry, Achal, your voice is getting disturbed
Hello,
in between.
hello.
Yeah, now you are audible.
Yeah.
Yeah, now you are audible
Okay.
clearly.
So
Yeah.
what we have done is this is just a gist of what we actually do in the course. This is just a,
Hmm.
major, like major one of the major clauses. And now I am gonna show you up what,
Hmm.
according to us, if we are representing our in-house legal counsel for a
Hmm.
service
Hmm.
provider, what needs
Hmm.
to be done. So obviously, if
Hmm.
if we actually look into the depth of this clause, we will
Hmm.
get to know about it, like what would be the exception or rejection in this clause.
Hmm.
So I'll
Hmm.
just
Hmm.
scroll it down, and then you can see what is the difference and what are the changes that needs to be
Hmm.
done, and that is quite important. This is what we basically teach in the course. Like, so Pragya will explain you the changes, all the changes that we have made.
Yeah.
Okay, Harsh, so first we'll come to clause 3.1. So 3.1, according to you, was good to go. Now, I'll tell you when you are working as an in-house legal counsel, what mindset you need to have. Now, if we read first line, it says subject to satisfactory performance. Now, when I come to the word satisfactory, satisfactory is a very blatant and a broad term. Now, if I accept this, how will I know on whose satisfaction, subject to whose satisfactory performance? Now you might counter that
Okay.
obviously it's going to be the client. Okay.
Hmm.
Now you are service providers legal counsel. Suppose your company has provided services for 30 days and once the payment is due, client says it is not up to my satisfaction level. I'll not pay. Can you make client liable in that situation? Because
No,
client says
because
it is
this is
not
a
up to
very
my satisfaction
yes.
because there is no satisfactory level defined.
Hmm.
Satisfactory levels can be different for you, can be different for me, right? So
Yes, it will be different
satisfactory
for
is
the
a very
for
vague
the
term.
hundreds of person. Hmm.
So this is the first reason, very first reason why we are saying why we have to delete the word satisfactory. We are agreeing to perform the services as agreed between the parties. And the services that has been agreed between the parties, those services would be defined under the agreement. The
Hmm.
services that are defined under the agreement, we will perform those services. You like it or not, that's a completely different thing. You don't like it, but I have performed the services. I need my payment, right? So that
Hmm.
is the reason why I will delete. First and foremost, I will delete the word satisfactory. Now the clause looks like subject to performance of services defined under the scope of work under this agreement. Now, as
Hmm.
I told you that the services that we are required to perform will be defined under the agreement. Now there is a scope of work that will be defined under the agreement.
Yes.
Once you enroll in the course, you will get to know the full-fledged agreement. Then you will get to know more about it. But just to give you a gist, the
Hmm.
scope of
Hmm.
services is always defined under the agreement, and under that agreement, you will see what other services that service provider is required to perform. So
Yes,
whatever
yes.
it agreed, we will perform. Once we perform,
Mm,
pay us. So we make it simple and clarified it, subject to performance of service under the scope of service as defined under this agreement by service provider. ABC shall pay the service provider fees as consideration. Now
mm,
you would see the difference by just removing one word. Our payment terms are secured. It states that if we have performed the services, ABC is liable to pay to us whatever the consideration that has been agreed. Okay.
mm,
Now, if we move ahead, it says service fee is inclusive of taxes. Now, inclusive of taxes, we never agree to inclusive of taxes. I'll tell you the reason why. Now, here you would say that GST is exclusive, so why we need to make it everything exclusive? The reason being, GST is not the only tax that you pay.
mm,
You can
mm.
be in numerous industries, and apart from GST, there are numerous taxes. So,
Yes,
if apart
obviously.
from GST, government levy any tax, will you pay from your pocket? No, it's
No.
obviously client's obligation. So
Yes,
that is
yes.
why you would have to make the taxes exclusive in its entirety. So instead of writing fee is inclusive of taxes except GST, we have written fee is exclusive of taxes in if any levied under the applicable law. We have removed rest of the language. And the last language says that payment of service fee will be subject to withholding taxes at applicable rate. That is fine. Now I believe you have certain understanding of tax deductible at source, right?
Yes, yes.
Okay, perfect. So you would have understood why the last language is agreeable to us, right?
Last time, the payment of the service fee will be subject to the withholding of the taxes at the applicable rates, right? This one.
Yes, right.
So, can you please elaborate on this? Even though the language
Perfect.
is simple,
Okay,
but I
I will.
want to know the practical insight. Yeah.
Yeah. So I'll tell you, even this is just one language, but the concept is very broad behind it. The concept is
Hmm.
known as tax deductible at source. So what happens is, I'll give you an example, simple example. You and me, we are entering into an agreement. Okay. You
Yeah.
are
Yeah.
client and I am service provider. Okay. I have
Hmm.
stated that I will perform such XYZ services and it's going to cost you 100 rupees. My service fee
Okay.
is 100 rupees. Okay.
Hmm.
And plus, let's assume 10% is the tax rate,
Okay. 110. Okay.
prevailing tax rate.
Yeah.
So total is 110, which you are liable to pay to me. Okay.
Hmm. Hmm.
Now, once the payment is due in corporate setup, what happens? You will not pay me entire 100% fees.
Hmm.
You will deduct 10%.
TDS.
10% TDS you will deduct and rest 90% you will pay me. 10% TDS, I can claim back while filing my tax returns, right?
Yes.
So
Yes. Sure.
I will get 99 rupees and you will deduct 11 rupees and you will deposit it with the government. So
Yeah.
it is a law mandated by the government. So this is what the line states, that although the fee is, it's not that you are deducting this 10% tax amount and you are keeping it with yourself. It's not that. I am going to receive it, but it's that just that I'm not going to receive it from you upfront. I'm going to receive it while I'm going to file my tax returns.
Idea. Yeah.
Yeah. Okay. So this is what the language states. So I hope it's clear now.
Yeah. It is now clear. Yeah.
Perfect. So you got the understanding in 3.1, the changes we have made, why we have made that, the understanding we need to keep in mind.
Yes. Yes.
Perfect. Now we'll move to clause 3.2. So in 3.2, you say that they can withhold, I can allow them to withhold my payments, but I cannot allow them to withhold GST. This is the first blunder that you would do when you are working as an in-house legal counsel, because I'll tell you reason why. There are two reasons. First of all, you can never allow client to withhold or retain your payments. First reason for
Yes.
that is first reason for that is you are deploying some manpower. Okay,
Hmm.
that
Hmm.
manpower is not free. It's going to cost you something, right? Client is
Yes.
going
Yes.
to pay you. Only then you will be able to pay
Then
your
I'm
manpower
going.
salary, right?
Yes. Then I'm going to make the payment to my supplier or to my employees. Yeah.
Right, exactly. Now you are a client. I'm a service provider. I have deployed 10 manpowers. Their salary is 10 rupees. You are supposed to pay me 100 rupees, and then only I'm supposed to pay them salaries. Now you say at the end of the month that there is such and such claim. I am not going to pay you 100 rupees. I am withholding it till the time dispute is settled. Dispute settlement mechanism. It's a
Take
lengthy
yes,
process.
yes.
It
Then
takes time. So till that point of time, I am going to provide you service and I'm going to pay my staff from my pocket.
no, obviously I'm not going to pay from my pocket. I need to insist on the
Exactly.
client to make the payment of my consideration fee, which is negotiated on the
Exactly.
basis of the agreement.
Exactly.
Yes, 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 yes.
Exactly. So this is the reason why you can never allow retention or withholding. It's not just GST for the entire service fee. You can
Okay,
never
for
allow
the
retention or
yes.
withholding. Okay.
Okay.
Now I'll go through the changes that we have made. ABC shall be entitled to indemnification right instead of retention or withholding. I
Hmm.
have deleted it, and instead of that, I have provided indemnification right. Now, can you brief me if you have idea about indemnification? What indemnification is?
Yeah, indemnification is to protect the other party from any of the loss or damages which would have occurred, but it would not include any indirect consequential, pecuniary, or the special damages.
Okay, that was very theoretical. So this is the reason practical and theoretical comes in very different. When you work as an in-house legal counsel, I'll tell you indemnification is indemnification. You are perfectly right, but it is a theoretical language. In practical, what indemnification means is indemnification is a process at length.
Hmm.
Okay. So, like you are client, I am service provider. I have provided you services. At the end of the month, you say that because of your manpower, I have suffered such and such damages to the tune of say 1 lakh rupees. Now
Hmm.
you have said this. Now you are claiming 1 lakh. Am I going to pay you straightforward 1 lakh?
No, you will not be going to pay me directly.
First of all, you have to prove that there was indeed a damage. Secondly,
Yes,
you have to prove that damage was on account of fault of my employee, right?
yes,
Only then there arose an actual claim. So indemnification is a process where first you will bring forth the claim to me that I have suffered say 1 lakh damage because your employee destroyed my hardware. Okay,
yeah,
after that, we will go to dispute resolution mechanism. There is another clause in an agreement. In every agreement, you will find that is known as dispute resolution mechanism. In that, you will
yes,
find there is a dispute resolution mechanism. Either we can go to courts, or either we can go to arbitrator, or either party can mutually negotiate and resolve the dispute. Whatever the
yes.
mechanism is provided, we will resolve to that course. Say it's written, we will go to courts of Delhi. Okay. So
Hmm.
now we'll go to courts of Delhi. There you will prove that there was a claim.
Hmm.
Okay, there was a damage that you suffered, and then second thing you need to prove is that the damage you suffered is because of an act of my employee. Once you have proved this, only then my liability arose. Before that, my liability didn't arose, didn't even start, right? So this is the
Yes,
reason why I have provided them indemnification, right? To not make it biased or one-sided, to keep clients' interest intact and to keep my interest intact as well. Because when
yes,
you
sure.
are negotiating as an in-house legal counsel, you need to be very careful that you need not make contract one-sided. You need to keep both the
Mutual.
interest
Yes,
of both the parties intact. Okay.
yes,
So I have modified it that ABC shall be entitled to indemnification right in the event service provider breaches any of the material terms of this agreement. Now after this,
okay.
you perfectly said that you need to have a cure period. If there is a claim and if it's remediable, tell me,
Hmm.
I'll remedy it. If I am not able to remedy it, then ask for a claim. It's not that there is a claim. You are into the business that I take the services, I'll make a claim against him, and I'll take the damages from him. You're not in that business, right?
Yes,
So
yes,
if the material breach is remediable, tell me, I'll remedy it. If I still am not able to remedy it, then you are entitled to indemnification, right? So I've added that, and ABC has duly informed service provider of such breach and have provided 15 days cure period. Now, cure period here is very important. That
hmm.
why? Because till the time the cure period, the breach is remediable and cure period is going, so a client cannot bring indemnity claim against me.
Hmm.
Okay, so this is
Yeah,
the reason. This is the reason why cure period is very important. And service provider fails to cure such breach within the remedial period until the same has been complied with or the requirements under the applicable law in relation to this agreement has been adhered to. Till here, rest of the line I have deleted The reason why, because I cannot allow retention or withholding. If I cannot allow
Mm,
retention or withholding, how can I even agree that I do not have, I will not be seeking any remedy for retention or withholding? Because I, at the first foremost point, I deleted that I cannot allow you to retain or withhold my payment. So then
my payment
I cannot
happens.
allow, right? So this is the reason why I have deleted the last language. So now my clause 3.2 looks like this. So you understand the changes that I have made, why I have made that.
Yes. I got into the thing until the same may comply with all the required replicants in relation to this agreement have been executed within from the settlement breach and per 15 days the QOP immediate detail. Yeah, Pragya, I'm good to go with this.
Perfect. So now you would have seen the difference between your thought
Yes.
process and what exactly we as in-house legal counsel need to think of while vetting the draft, right?
Yeah, because even I am also looking into the agreements of my company day-to-day basis, and even now I've just started, so that's why I am now eager to join such courses and to get into the better understanding that how can these agreement can be negotiated, can be drafted from the scratch in this point. That's why I joined this this session.
Perfect. So I believe Achal, we have another entry. Ashutosh, hi Ashutosh. Good afternoon. I hope you are doing well. Ashutosh, are we audible? Okay,
I think
okay. I'm not
Pragya,
sure if you are audible.
Pragya, let's just continue with the session. We can just provide them with the recorded session of it.
Perfect. So yeah, Harsh. So as you have seen that the drastic change in mindset when you are actually working on an actual contract, and you would have understood that theoretical knowledge doesn't help you
Well,
there.
yeah.
So right. So now Achal will take it ahead, show you what exactly is the course all about, how many sessions, what all are included in the session. Achal, over to
Yeah,
you. Thank you.
thanks, Pragya. I think it was a lovely explanation and a very detailed explanation. So like just before moving ahead, I'll just tell you what we basically do is we this course is whole and whole designed out of the practical insights and aspect to the contracts. When we say it practically, obviously, as we all know, you cannot learn driving in a four wall, like within the four wall, right? You cannot
Yes.
learn swimming with the knowledge given in books. You will only get to learn about it when you will jump into it. So that's what me and Pragya thought about it. There is a lot of theoretical knowledge when you search on Google and internet. You Google anything, you get a lot of theoretical knowledge. But when you see things practically, if you talk about contract negotiations, redlining, it is something which we call as an art because it will differ. For me, the contract redlining would be different. For you, Harsh, for Pragya, or for Ashutosh, it would be really different. So it's like you'll get to learn when you will actually do it from scratch. So I'll just quickly run through you to the like the all everything about the course that we have designed and how does it work and what all is included. So my screen is visible, right, to everyone?
Yes.
Okay. So
Yes, yes.
why
It
we
is.
have mentioned it as a zero to hero?